Please enter your conference ID.
Please enter your PIN number followed by the pound key. Welcome to the conferencing center. This event is being recorded.
Hello, and welcome to our national webinar, Madrid Protocol, Obtaining and Maintaining International Trademark Protection. If you're not satisfied with the sound from your computer speakers, please just call in and listen on the telephone using the dial-in instructions we sent you previously. You can switch to telephone audio at any time. After the presentations, we will conduct a live interactive question and answer session. During the webinar, you may email your questions to iplaw@stratfordpub.com, or you can submit questions anytime by typing your question into the Q&A box that you'll find on the right side of your screen and pressing Enter there. As always, the views expressed during today's webinar are those of the speakers, not of Stratford, the speakers' firms, or clients, and are not intended to provide legal or tax advice. We have gathered a panel to guide IP counsel on the Madrid Protocol, including the application examination process, how and where to file, amending an application, and dividing a registration. The panel will examine how to respond to a notice of irregularity from WIPO, apply for subsequent designations, and use the e-renewal process. The group will also discuss the limitations or drawbacks of the system. Our panel today includes Barbara J. Grahn, partner at Fox Rothschild. She's joined by Roberto Kunz-Holstein, partner at Dr. Kunz-Holstein. Panelist, Roberto, when you're ready, we'll get started.
Thank you. Welcome also from my side. We shall talk about the Madrid system, or rather the protocol. Now, what is Madrid? The Madrid system consists of two international treaties, the Madrid Agreement, dating back to 1892, and the Madrid Protocol from 1989. Both treaties are centrally administered by WIPO in Switzerland. For those of you who come from the patent side, the Madrid Agreement was the blueprint for the PCT agreement. The idea behind the Treaty of 1892 was to allow trademark owners a cost-effective one-stop extension of their existing trademarks to other member states of the agreement. Later, the protocol has been added, mainly to facilitate the joining of the USA. The protocol does contrary to the agreement, not require a registration of a trademark, but allows you the extension of a pending application. Also, the protocol allows the trademark offices the collection of individual fees. The following, we will just focus on the protocol to which the US is a member. The US did not join the agreement, with the consequence that you cannot designate countries that are purely members of the agreement. However, this is right now no longer an issue because all members of the agreement are members of the protocol. As I said, Madrid offers a simple and cost-effective possibility for obtaining trademark protection in a high number of states. Currently, altogether, 107 states or regions, like the EU, have joined the protocol, allowing you an extension with one application to up to 123 countries. Many important countries or regions are covered. The entire EU, with the exception of Malta, the NAFTA area, so the US, Canada, Mexico, key countries in Asia, Japan, Korea, China, also Singapore, Malaysia. There is a gap with respect to South and Central America. Currently it's only Brazil and Colombia and Mexico, but there are discussions now that Brazil has joined with Chile and Argentina, which will hopefully become members soon. Now, under this system, one application for an international registration is equivalent to the filing of the trademark in the requested member states. For historical reasons, ones I gave before, the international application must be filed through the Office of Origin, in your case, the USPTO. And the international application needs to be based on at least one national application or registration. However, in practice, you can also combine several national trademarks as basis for one international registration. So if you own a trademark in class 5 and the same trademark in class 10 with a different registration, you may nevertheless file one international application covering both classes 5 and 10. The international application must be within the scope of the national basis. Evidently, owner and trademark must be identical. Also, while you may file for more limited goods than your original national trademark, so you can omit classes or single goods, you may not seek a broader scope of protection than your basis enjoys. Finally, or more important, the applicant must fulfill certain requirements with respect to the country of origin. The applicant must either be a natural person or a legal entity which has a real and effective industrial or commercial establishment in the country of origin, or is domiciled in this country, or is a national of this member state. The requirements or the criteria are all evaluated under national law. WIPO will not verify if the conditions are fulfilled. You may state whatever you want in the application form. WIPO will just accept it. The question will come up, though, once you try to enforce the trademark. Now, the Madrid system offers many advantages. The main advantage is, of course, its cost effectiveness. Instead of having to file up to 107 applications, you may just file one with WIPO through the USPTO. There are no administrative requirements, since there is no need to provide certified copies of the home registration, translations, powers of attorney, or anything else. The USPTO does the certification for you. By ticking the box of the respective country in the application form and by paying the necessary fees, you will receive the equivalent of an application in this designated state. If the extension is not objected to within a certain time limit, you will receive automatically the equivalent of a national registration without further actions. There is an exception to this. A couple of member states require you to pay additional registration fees. We will explain this in more detail later. You have to pay these fees directly with WIPO and not with the national states. An international trademark obtained through WIPO grants you a bundle of identical national rights. This allows a greater uniformity of the trademark portfolio, as all trademarks normally enjoy protection for the same goods or services and for the same period of time. Having just one point of contact, the WIPO, makes managing and maintaining the trademark rights easier. Limitations, withdrawals, restrictions, assignments may be filed with one application directly with the International Bureau. In this respect, the Madrid system offers you a high flexibility. You may renounce to the entire registration, only to the extension in one member state. You may limit the entire registration or request the limitation to have effect just in one member state. Also, an international registration may be renewed with one application without the necessity of proving use. Essentially, all you have to do is pay the renewal fee and file the application. The data advantage does no longer apply to all member states. Mexico, the US, and the Philippines require a national affidavit of use. Again, we will discuss this later in more detail. All forms to manage the international registration are available online. The link is on the slide. Be aware, WIPO has introduced new forms as of January 8th of this year, and they require you to use the new forms. Another advantage of the system is that you can apply for multi-class registrations in those countries which normally only allow single-class application. A word of caution from my side: some member states don't manage to handle these multi-class applications thoroughly. Especially with India, I had several cases where the Indian Trademark Office forgot to deal with all classes and forgot some. Also, there's the possibility of so-called subsequent designations. Once you have an international registration, you can, by filing a respective request with WIPO, obtain protection also in those member states to which the international extension had not been granted previously. Again, we will discuss this in more detail later. Finally, there's a practical advantage. The offices, the national offices, have a time limit within which they must issue a refusal if they want to object. Normally 18 months. If there is no refusal after 18 months, the trademark is deemed to be granted. In practice, there are several national offices which never make it in time to express a refusal. Now, compared to these advantages, there do not seem to exist reasons for favoring national applications. But there are some disadvantages you should be aware of. The main point of criticism is the dependence of the original national registration of your basis. It is only after 5 years following registration of the international registration that the international trademark becomes independent. Until this date, it shares the fate of the registration in the country of origin. So, any restriction of the list of goods, during the period of dependence becomes effective for all designated states. Worse, cancellation, withdrawal, or refusal within the period of dependence leads to the cancellation of the entire international registration. This dependence offers you or third parties the possibility to challenge an international registration comprising all its sections by attacking the home registration within the 5 years period. This procedure is known as central attack. Even though this is often considered as the main disadvantage of the Madrid system, the possibility of such central attack should, in my opinion, not raise much concern. Experience, at least mine, shows it's hardly ever used. Also, in the end, it poses an advantage. Instead of having to litigate in several states, you can defend your trademark on your home forum. Also, the problems arising from the dependence of the national trademark are mitigated by the fact that the protocol offers the so-called transformation into national applications and thereby retaining the priority. Such application for transformation must be filed within 3 months from the date on which WIPO canceled the international registration. The applications must be filed not with WIPO, but with the national member states into which you want to go with your transformed trademark. Be careful, the option of transformation is only available when the international registration has been cancelled at the request of the national office, in your case the USPTO. It is not available in cases where the trademark has been cancelled voluntarily upon request by the holder. This may be important in settlement agreements. Barbara?
Thanks, Roberto. I was taking notes as you were speaking. So I'm going to speak a little bit about the actual filing process in the U.S. for U.S. trademark owners designating under the Madrid Protocol. So where you start with this on the PTO website is in the TEAS forms, where you typically go, the TEAS-I forms. And as you probably know, Section 11 there contains the Madrid forms. So the application for international registration is there. As Roberto mentioned, you can base a Madrid application on a single registration, a single application or registration in the U.S. or multiple. It affects the cost a little bit because the charge for the U.S. by the USPTO for certifying is $150 a class if you base the application on more than one U.S. application or registration, and it's $100 a class if it's a single application or registration. When you file the application with the USPTO and base it on a single application, the application auto-populates. So it's really quite easy. One thing you do need to be certain of is ownership, that you have the proper ownership information in the U.S. database, because if that information is incorrect, which sometimes can happen, say you filed an assignment, the PTO hasn't updated that owner information, you want to make sure that that's updated before you file your Madrid application. So just make sure that all the information in the U.S. Application or registration is the way you want it, is the way it should be, that it's all up to date and correct for the Madrid. Another thing you need to be aware of that sometimes is confusing is that if you are claiming priority, which you can do, you can claim priority from a U.S. application within 6 months with a Madrid filing, you have to enter the priority information separately, and it's duplicative. You must enter the serial number of the underlying application, the filing date, the goods to which the priority claim applies to, all of the priority information. It's there in the form, just don't overlook it. You have to re-enter the priority information. You have the option of filing for some or all of the goods in the underlying application or registration. You can limit the goods in some countries and not others. It's very flexible. For example, if you know that you have a conflict in a particular country, or maybe you have some goods and classes that are not as important to you as some of the other goods, you have the option of filing for only some of the goods or in only certain classes when you file the Madrid application. So again, it's flexible, and you have all these options. If you are filing on based on more than one basic application or registration, or if the information from the underlying application doesn't appear in TSDR yet, you have to use the free text form to complete the application. So just something to be aware of. Usually, particularly since if you can claim priority, it makes sense to wait for that information to show up in the PTO records. But again, if you are relying on more than one application or registration, you need to use the free form text entry. One thing to think about when you're filing or to be aware of is that some countries do not allow reclassification of goods or addition of any classes once you file the application. China is the one that comes to mind for me, but they will not allow you to add classes to the Madrid application, and you won't be able to get those goods registered if they are misclassified. So for example, if you ever use the strategy of putting all the goods or services into one class, because the client doesn't want to pay filing fees or because you want to see if the application is going to go through before you add classes, be aware that this may prevent you from seeking registration for all the goods or services in some countries. So you may want to make any amendments, if possible, before you file. The WIPO should issue, and typically will issue, a notice of irregularity if goods are misclassified. They don't always do this, but often they do. Sometimes also I've found that WIPO doesn't agree with the classification that the USPTO uses, or the USPTO will accept a classification of goods or services that WIPO doesn't agree with. So in that case, you may get a notice of irregularity from WIPO telling you that you have to reclassify or amend the goods. WIPO will also issue notices of irregularity if they disagree with your description of goods, if they find it indefinite. We can talk about that more later if we have time. You can respond to those, or you can not respond. And Roberto, correct me if I'm wrong, but WIPO will then go ahead and report out the application with the goods as you have described them, but with a note that they consider them to be indefinite. In terms of the filing process, you can pay through your USPTO account, but there's an option to pay through a WIPO account. One tool that WIPO makes available that I've found very helpful is a fee calculator that calculates the cost of the application. So there's a link on the slide for the fee calculator. There's a basic fee, 653 Swiss francs, and then the individual fees vary by country. Again, it's all you can know that ahead of time with the fee calculator. It's also helpful in providing cost estimates to clients to use the fee calculator. I've found that it's not exact. Sometimes there are changes or have been changes in the fees, or the exchange rate may change, or if you're using a credit card or deposit account. So there may be small adjustments, but it's a pretty good idea of what your fee is going to be. It just may not be exact. Also, the USPTO charges the $100 per class to certify the application to WIPO. If it's based on a single underlying application or registration, and as I mentioned earlier, if it's based on more than one application or registration, the certification fee will be $150 per class. And when you're preparing the application, getting ready to file, it does show you what the fee is before you actually file the application. So when you submit your application, you immediately get a success message. If you don't, you better figure out what's wrong, because typically you're gonna get a message that your application was successfully submitted, because it may take a while before you get any confirmation. You'll get a confirmation of submission from the PTO, but what you want to be looking for is that application has been certified by the PTO to WIPO. Now, when you use a single underlying application and you don't make any changes in the information that's in that application or registration, the Madrid application is what we call auto-certified. The PTO will just send it along to WIPO without really examining it. Now, it traditionally has been not instantaneous, but it's been a very quick process for the USPTO to certify that application to WIPO. That process is slowed down. I think it must be COVID related. I just got an auto certification notice. They're still auto certifying them, but it took 8 days. So things are taking a little longer than usual. It's probably a good reason to make sure that you get your application. If you have a priority deadline, get it in. It won't affect your priority deadline as long as you get the application filed. But you just want to make sure that everything is in order and sent along to WIPO. So just keep in mind that that's taking longer than usual. Again, if you change anything in the application, change the goods for some countries or all, don't file for everything, then the PTO will take a look at that and review it before they certify it to WIPO. Roberto?
Yes, thank you. Once WIPO receives an international application from the USPTO, it should do so within 2 months following the filing. It examines the application exclusively for formalities. If no objections are raised by WIPO, you will receive a certificate of registration, which is in the end just a filing receipt of your international application. The trademark will be published and the single member states notified. Beware, there is a 9-month deadline within which you must request the correction of errors. I never found it necessary to mention this before, but since last year I've seen more and more errors in international registrations. I recently had a case where the USPTO notified the correct trademark to WIPO, but WIPO somehow managed to register the wrong mark. As I said, there's a 9-month deadline, which starts from the publication. if you are late in requesting correction, the worst that can happen is that you will have to file again. In theory, WIPO must correct an error even after 9 months. If it's their fault, somehow it's never their fault. If WIPO has objections to your international registrations or international application, you will receive a so-called irregularity letter, setting you a 3-month deadline to reply. This 3-month deadline is not extendable. There are mainly 3 types of irregularities: a formal error by the Office of Origin. So if the USPTO makes a mistake, WIPO will come to you, and then you will have to go to the USPTO telling them to correct it. The other errors are errors in fees if you have not paid enough, or if the fees have changed between the filing of the application and the receipt of the application by WIPO, or errors in classification or wordings of the list of goods and services. Concerning the list of goods and services, there are 2 types of irregularities, or 2 types of questions WIPO raises. One is they will tell you, we believe the goods to be too vague. You may reclassify them or you may rephrase them. If you don't rephrase them, we will just register it as you have claimed it, adding a note that we believe them to be too vague. Then you have to decide if you want to specify them further or if you will just accept it. The other possibility is that WIPO tells you, we do not accept this wording or the goods in this class. Then you have to react. Otherwise, the international registration will be refused for these goods. It is important to know that a reply to an irregularity notice must be filed through the Office of Origin. And this Office of Origin must forward your reply to WIPO within this non-extendable deadline. So make certain that your reply reaches the USPTO in time. For our office, we normally docket 1 month ahead of the actual deadline. Now, as I said, if WIPO is satisfied with the application, it will issue a certificate of registration, and it will notify the single designated chosen contracting parties. Following this, the proceeding turns factually into a national proceeding. Each designated party will conduct their own examination according to their own rules and proceedings. If they want to object to the extension, they will issue a provisional refusal, which will be sent to WIPO, and WIPO notifies to you. You will then have to deal with the refusal before the national office, mostly through a local attorney. Now, the important thing about the refusals are the deadlines. The problem is, since each member state has its own rules and proceeding, each national deadline starts at its own date and has its own length. This requires you to carefully study the refusals. Some countries are nice and expressively indicate the deadline. Others let the deadline start from the date of receipt, either by WIPO or by the owner or the mailing date, and simply mention the length of the deadline. The possible length of deadlines varies considerably. There are some countries which grant you even 24 months, while others have a limited number of days. The shortest is China, which sets 15 days. The allowance of extension of these deadlines varies. In some countries, the deadline cannot be extended. There are even some jurisdictions, mostly former Russian countries, who require you to present all documents for overcoming the refusal, which often includes a legalized power of attorney, within the deadline set. So start working early. As I said, the requirements for replying to the refusals are governed by the single national law. As a consequence, they vary from country to country, of course from case to case. There's no uniform way of replying. A first overview may be obtained on WIPO's internet page, which contains a summary of the national proceedings. I've put the link there. Be aware though, the information is not always accurate or complete or up to date. WIPO has to rely on the information the member states give them, and if they change their law, sometimes they forget to notify WIPO. Verify with a local colleague. In fact, most countries require you to file the reply through a local attorney. In this respect, there are some countries who require you to first and especially appoint a local attorney to whom the full refusal will be sent. Switzerland and Germany are examples. The consequences of missing this deadline are the loss of the extension. The refusal will be confirmed regardless of the merits, just because you did not appoint an attorney. Occasionally, you will receive from WIPO a letter with a so-called irregular provisional refusal. WIPO tells you this is for your information only. Basically, this concerns refusals that have been expressed after the relevant deadline or which do not contain the necessary information for often a refusal. I would nevertheless recommend to verify with a local colleague in these cases. From a legal point of view, you should be good, because if no valid refusal, then according to the protocol, you have protection, equivalent to a national trademark. However, there are some member states who simply do not care. They mark the trademark as refused in the national database, and then you will have a surprise once you try to enforce it. Some countries cite earlier trademarks comparable to the USPTO. In these countries, there are mainly the following options or possibilities to overcome the citation. Many jurisdictions allow you to overcome a citation by submitting a letter of consent. Again, the requirements vary from country to country, but as a general rule, the consents should be kept simple. I've given you a draft on the slides. In my experience, it works in many countries, but you should verify with your local colleague. A word of caution, especially in former USSR states, the consent needs to be irrevocable, and this must be stated on the letter of consent. So they look for the sentence, this consent is irrevocable. Alternatively, you may try to overcome the citation by limiting the list of goods to exclude potentially blocking wares. Some trademark offices are really nice. They tell you, if you renounce to A and B, we will allow the trademark to proceed. If allowed by this jurisdiction, you may file then a request for limitation, just for this country, with WIPO. And what you should do is make certain that the National Trademark Office is made aware of the limitation, as otherwise the refusal may be confirmed. Especially Japan and Korea are extremely nice. They basically tell you what to send to WIPO and give you an email address to where you should send the confirmation that you have done so. And then they reply to you saying, we'll put the examination on hold until we receive confirmation of the limitation, and then issue a statement of grant. A brief excursus as to limitation. As I said, you can file a limitation directly with WIPO, with a Form MM6, which is available on the website and which may be submitted online. This you can always do. On the other hand, there are some jurisdictions where you can limit through the office of the designated party. Again, inquire with your local colleague, is this possible? If not, you have to go through WIPO. In this case, also the former Russian states or former USSR states are difficult. They require you to have, or some of them require you to have the limitation on file with WIPO before the expiration of the deadline. If you cannot overcome by letter of consent because it's not accepted, or if you can not limit the goods or want to maintain the goods, there's the final alternative, which is the so-called temporary assignment. You need to negotiate with the owner of the blocking registration that you may assign your international registration for this member state to him during the period of examination. And once examination is completed, it is reassigned back to you. As to the procedure, you request with WIPO a temporary assignment of the single designation to the national member state with the Form MM5, which you file with WIPO. Then you provide the information to the national office, either personally, where possible, or through a local attorney. After the statement of grant, this is important, not after the acceptance, but after the statement of grant, you file a request for reassignment with WIPO, following which the trademark will again be owned by you, and then you file an application for merger with WIPO of the two international trademarks back to one. Once you have overcome the refusal, in theory, the member state should follow up with the final decision. meaning they should send you either a statement of grant or a decision that the refusal has been reversed or a certificate of registration. In practice, some countries take years or forever to do so. Again, verify locally if the mark is important or the country is important, that indeed the grant has been given, because otherwise you will have a surprise when trying to enforce. I've spoken to WIPO officials, and this is just an overview of the most common errors when filing or dealing with international registrations. The first is email. When indicating an email address in the application form, WIPO will always use this email address to notify you. They will not come after you if it doesn't work. So use an email that is unlikely to change, and if you change your email address, make certain that WIPO becomes aware of it. The second error is the deadlines. Again, some are not extendable. Some require you to fulfill everything necessary, especially the power of attorney, to be presented within the deadline. Another common error is the reply. A reply to irregularity notices by WIPO must be filed through the Office of Origin and not directly with WIPO. By contrast, a reply to a provisional refusal must be filed with a designated national origin office and not with WIPO. All right.
Thanks, Roberto. So, sorry. So I'm going to just talk briefly about how the registration, the international registration, and kind of how that process goes forward. I think Roberto mentioned earlier that if a member country who's notified of the designation does not respond, doesn't either grant or refuse protection within 18 months after the date that WIPO notifies the office of the designation, then the mark is deemed registered in that country. So if there's not a refusal within that time, it's considered registered. So you may hear nothing from some countries that you designate. Some countries will issue a notice saying it's going to take us longer. We're not going to know within the 18 months, kind of extending that deadline if the opposition process is longer, or maybe if an opposition is filed. But if you hear nothing within that 18 months, there's this tacit acceptance of the registration, and so the mark is protected. Now, as Roberto also mentioned, you might get sort of a late response or a late action, and I have never had that happen, but I assume there's a way that you can challenge that. Many countries will issue kind of an interim status report, and they'll send you a notice that says, okay, the mark's been examined now, and it's going to be published, and they'll tell you the date when it's going to be published. Or there will be just a notice telling you that the examination is complete and that there's no, they've found no reason for refusing the mark. But generally, the mark will be published in each country. The final issuance or the final acknowledgement of protection is usually either a statement of grant of protection, which is just a short notification, usually saying that the opposition period has expired, there haven't been any oppositions filed, and the mark is now protected in that country. Some countries issue their own registration certificates. The U.S. issues registration certificates for Madrid designation. Japan still issues registration certificates. There are other countries that do as well. One thing to be very aware of, something I'm always double checking, some countries, Brazil, Japan, Cuba, I guess, require payment of what they call a second part fee. And usually this fee is payable after the examination, after the application has been examined, but before it is published. So this is a fee payment that goes to WIPO. If you do not pay the second part fee, the application, the designation for that country will be abandoned. You will lose your chance of registration in that country. You can refile, but if you have a priority claim or something, you would lose that. So be sure to follow up on those notifications that a second part fee is due. And you can do that. You do that right with WIPO through your WIPO account or however you make your payment at WIPO. But that's not something that you want to overlook. The WIPO website offers a lot of e-services. There are many tasks that you can complete on the WIPO website. So, for example, you want to get e-notification that will give you email notification and copies of the notifications from the offices. You can sign up for those. There are Madrid Monitor e-alerts, which sends an alert every time the status of an IR is updated. Now, I know at our firm, our docketing department has the Madrid Monitor is set up for e-alerts on all of our Madrid filings, so they get an alert immediately when something changes. There's also the Madrid Portfolio Manager. You have to have a user account. So it's easy to set up a user account with WIPO, and you do have to have an account for certain things that you want to do there. But the Portfolio Manager, I don't use it personally, but it certainly is an option. You can also, you have to file your original initial application for international registration through the U.S. PTO or whatever the country is that you're relying on the underlying application. But you can do all of these things on the WIPO website through their e-filing system. So you can do a subsequent designation, you can do renewals, you can make additional payments. So if you get a notice of irregularity that says you owe more money, you do that right on the website. You can do an e-limitation if you want to limit an application for some reason. So all of these e-services are available there. It's pretty user-friendly. It's not too bad. And you can get a lot of things you can file directly and accomplish on the WIPO site. There's also this, it's not that new anymore, I guess, but the WIPO IP portal. My unofficial survey of the IP portal is that most people don't use it. I don't use it. Roberto doesn't use it. I've talked to some of my colleagues. They don't use it either. But it does have a lot. It's kind of a central location on the WIPO Madrid website where you can kind of access a lot of services. You can keep track of things. I think it might be, if you have a lot of different clients, owners, that sort of thing. I just haven't found it very useful, but you do have to have a WIPO account in order to use the IP portal. So you can explore that, see what you think. If anybody has favorable experience with it, I'm happy to know about that, but it's not something that I use. So there are a lot of useful things on the WIPO site, but one of the things that you can do and probably should be doing is tracking your applications. I've just taken some screenshots here that show you what you can do. Typically, you go into Madrid Monitor. You can do a search by mark. You can do it by registration number. There's an advanced search option that you can use. I don't find the Madrid Monitor searching particularly user-friendly, but you can usually, if you know what you're looking for, that's a good way to get into it. So here is a page from Madrid Monitor that just shows you what some of your options are and how you can search by registration number, the WIPO reference, office reference, that would be the USPTO reference, and some of the other search options. But the way that I use this a lot is in kind of tracking the status of an application, making sure that things have been, when things have been filed. So if you look at this slide, you will see this is the real-time status of an application. You can search, these are different registrations listed here. They have a WIPO reference, and then you see, I'm sorry, this is the application. So this shows you when your application was filed. Here's an intermediate status report, and it tells you which country that's from. It says it's from the European Union. That's probably a notice that says your application has been examined and there's no reason has been found to refuse it. Then you kind of have an intermediate status report here. All right, so we filed a change of name or address here. Then you see a grant of protection. So you can just kind of see everything that has occurred with that application kind of in date order. You can also find, and this is really useful, a summary by office. If you see the tabs up here, you see the full details of the application, then a summary of the application. But when on this by office tab, here are all the countries or members that are designated. These are all drop-down menus. So you can expand that line, and it's going to show you all of the communications to WIPO from that country. So you might have an interim status report. You might have a notice of provisional refusal, and then you might have a subsequent statement of grant of protection that might be for some or all of the goods. If you might have a statement of grant of protection after provisional refusal. But in any case, you can go to any one of the countries that you have designated and check and see what the status of the application of the IR is in that country by using this summary by office page. So you can explore that a little bit. You can do a lot of things with that website. And I find that I refer to it quite regularly and find it very useful. There are PDF images there of the notices that have been sent out by the various designated countries. Here are some of the special considerations that you need to be aware of. We've mentioned some of them in passing. The big one, and the one that you always need to be aware of and need to make sure that you notify your clients about, is that if you are handling a designation under an IR in the U.S., once the mark is registered in the U.S., it's treated like a U.S. registration. You must continue to file, with respect to declarations of use, you must continue to file your declaration of continuing use between the 5th and 6th year after registration, and then by the 10th anniversary of the U.S. registration date every 10 years, just as you do with the U.S. registration. Now, of course, the renewal of the U.S. registration is accomplished through renewal of the IR, but you can't miss these maintenance filings, declarations of use that have to be filed on the same schedule as for any U.S. registration. And that's the case in a few other countries here that Roberto will mention. But the other thing to keep in mind in the U.S. is that, well, there is a grace period. There used to not be, when they first initiated this, there was no grace period. They have the same 6-month grace period. Roberto, do you want to talk about Mexico and Philippines?
Yes. The other two countries which request comparable to the U.S. affidavits are Mexico and the Philippines. Basically, it's what they do with their national trademarks. So in Mexico, you have to file a midterm declaration, which is the so-called third-year declaration, which must be filed within 3 months following the third anniversary of the grant of protection by the Mexican Trademark Office. The date of the grant of protection is expressively indicated on the statement of grant you receive. And then you must file a further declaration within 3 months following the renewal notice of the IR. The Philippines asked for a little more. Within 3 years from the date of the international registration or the recording in case of a subsequent designation, the recording of the territorial extension to the Philippines, you must file the 3 years declaration. A second declaration is due within 1 year from the 5th anniversary of the statement of grant. Again, this is indicated on the statement of grant you receive from the Philippine Trademark Office. And then, within 1 year from the date of renewal of the registration. I'll go back a couple of slides. Sorry. We jumped. Oh, sorry. To complete the e-services. The subsequent designations. The Madrid system recognizes so-called subsequent designations. You may file this subsequent designation online via WIPO's internet page. The link will be on the last page of the slides. All you have to do is enter the registration number, select the member states or the member state, as well as the method of payment. Again, you may choose to extend only for some classes or even for some goods only. By filing a respective request with WIPO, protection may be obtained in those member states to which the international registration had not been extended before, or even to those countries which have joined the protocol after the original trademark registration has been obtained. There are some countries who do not accept this. This is Brazil, Estonia, Namibia, Philippines, and India. They require you to file a new international registration. There's one important point. The life of the subsequent designation is, as far as WIPO is concerned, identical to the duration of the IR. So if your mark comes up for, or is coming up for renewal, wait for the renewal to be recorded before applying for the subsequent designation. Otherwise, you have to pay double fees. Also, another important aspect is when you deal with old international registrations. In case the old international registrations enjoy protections for goods that are now classified in different classes. For example, for a long time, nutritional supplements were either in 29 or 30 and are now in 5, or vending machines used to be in 7 and are now in 9, or vice versa. There are some countries who do not accept reclassification. Meaning, if you are extending such an old international registration, they will tell you these goods are not properly classified. We do not accept them in this class. You cannot reclassify them. That's it. Another e-service is the e-renewal. Oops. The e-renewal, again, you just pay you just indicate the trademark number and you pay. That's it. You can only renew the entire IR you can limit the member states, but you cannot limit the goods and services. If you want to limit the renewal to certain goods and services, you have to apply for the limitation with WIPO before the trademark expires, and the limitation must be entered before the beginning of the grace period. Otherwise, WIPO will not accept the partial renewal, but will request the full fees from you. E-payment, Barbara has discussed. And then there's also a new tool which came up, I think, this December. It's e-limitation. Instead of using a paper form, you can also apply for a limitation of an IR electronically. I've tried it. I don't like it because you cannot specify. You can just renounce. I therefore use or continue to use the paper form.
Thanks, Rebecca. We need to at least mention China here. You may have heard a lot of people don't like to use Madrid or don't use Madrid for China. And one reason behind this is that China treats designations under IR differently than national applications. If you file a national application in China, you must use standard descriptions of goods and services. China publishes something, it's similar to the goods and services manual that the USPTO has, but if you file a national application, you must select the goods and services from those standard descriptions. When you file a Madrid designation, that's not the case. They may still have objections to goods and services, but they don't strictly require you to designate standard descriptions. By the same token, you don't control then how those services or goods or services are necessarily classified, or more importantly, subclassified. China adheres really strictly to this subclassification system, where they will not allow the same or confusingly similar mark to be registered within the same subclass, really regardless of what the goods or services are. If they are in the same subclass, they are considered related, the marks can't be registered. So you kind of don't have any control over that, whereas if you file directly, you have some control over the standard descriptions that you can choose or select. So I think it's something that you need to look at. The China descriptions and subclasses are available online. You can look at them, you can select them. Sometimes you use them if you have to reply to a refusal and choose and revise the list of goods or services. But some services are more suitable, I guess I would say, for they correspond rather directly to some of the subclasses in the Chinese system. So medical devices, for example, there's one large subclassification for medical devices that doesn't, I think it excludes electronic ones. So if you think that the goods and services are suitable that way and readily subclassified, and that there's a clear subclassification for the goods that really isn't going to be that different, that's one thing. But I find that with a lot of Class 42 computer services and things like that, it's really a little more difficult and a little more unclear. But it's something to be aware of. It's just that in China, you may not want to use a Madrid designation. You might want to do a national designation. I have done both. So you may want to do a Madrid designation, but also file a national application to just kind of make sure and maybe one will go through and not the other, or you have coverage for your actual goods, because of course what you find with the standardized goods is that very often they're not very appropriate for your goods or services. You kind of have to fit your goods and services into these standard descriptions, and they're not always very good. So something to think about if you are designating China or wanting registration in China. Roberto?
Thank you. Let me briefly speak about Brexit. Now, on January 1st, the UK left the EU. Until this day, all international designations of the EU covered the UK. The same, of course, applied to the international applications. Now, from this day, this is no longer true. What are the consequences? If you have an existing international designation of the EU, which the EU IPO has granted protection to before January 1st, 2021, there's nothing you have to do right now. On this day, a comparable or identical national UK right has been automatically created. It's a national trademark, not an international registration covering the UK. The next important deadline for you would be the renewal deadline. Then, when your IR comes up for renewal, you also have to renew this national UK trademark. This is not applicable to those international extensions to the EU which have neither been refused nor protected, meaning they are still pending for whatever reasons before the EU IPO. These are not replaced automatically. You don't have to, but you may apply for a national trademark registration before the UK Trademark Office within 9 months after Brexit date. This will allow you to maintain the original priority. This is also true for those trademarks which have a registration date prior to January 1st, 2021, but which have been notified later. The reason for this is you will get as a registration date the day on which you have filed the international extension with the USPTO. So if you filed on December 29th or December 31st an international application designating the EU, you will have a registration date of prior January 1st. Of course, it will only be notified afterwards. But nevertheless, since your registration date is prior to the Brexit date, you may still file for a equivalent national application within the 9 months. My last point, licenses. You may record licenses with WIPO. There's a special form for it, and then 13, again, available on the web page. You can file it directly with WIPO, and the nice thing is WIPO doesn't request you to present a license agreement. They just accept your application and request some fees. Two things that are important to know. There are 2 countries which do not recognize recorded licenses at all. These are currently Australia and New Zealand. And there are some countries which do not recognize the recordal at WIPO. These countries request you to file the license directly with the national office. The most important are Brazil, Canada, China, Japan, Malaysia, Mexico, Korea, Russia, Singapore, Thailand.
Thanks, Roberto. So we've included some links here to various pages on the Madrid, on the WIPO Madrid site that are helpful. So there's the Madrid homepage, the forms, Madrid Monitor. I keep a lot of these just on my favorites most of the time. But there's also a wealth of information there. It's just sometimes hard to find exactly the information that you need, but these links are usually helpful. And then, of course, from the Madrid Monitor page, you can go and find the record for your registration and look through some of the other information that we had in our earlier, in the earlier slide of the pages that you can use to monitor your applications and your registrations on WIPO. I think that we're done with the formal presentation. There was one, I think for Roberto and I could probably tell some more stories, but there was one thing I wanted to mention, and it's mainly a cautionary tale about responding to notices of irregularity in good time. I had a situation recently where I had two international registrations, two marks, a logo and a word mark, and we got notices of irregularity from WIPO with identical objections and identical, there were some objections to classification, there were some objections to specific goods and services. We responded identically for the two registrations. And the USPTO, those responses were picked up by or assigned to two different examiners at the USPTO, and one of them was approved and sent to WIPO, and the other one was refused. They were identical. I tried to, when I got the notice that one of them had been refused, there wasn't a lot of time left, and I couldn't get in touch with the examiner, wasn't sure why it had been refused. Anyway, it took a lot. Eventually, I communicated directly with WIPO, kind of saying, I don't know why the USPTO accepted one of these and sent it on to you and refused the other one. But again, as we've said, you have to respond to these notices of irregularity through the USPTO, and those are the kinds of unexpected things that maybe can happen. So I guess the advice is just make sure you have enough time to deal with a refusal, because you can deal with a refusal much as you would a refusal of on an application, on a U.S. application, because in this case it involved the second examiner had objected because she thought that the proposed amendments that we submitted in response to the notice of irregularity expanded the scope of the goods. So after we were able to discuss it and explain our thoughts about why it wasn't an expansion of the goods and services, she was fine, but by that time we could no longer respond to the initial notice of irregularity. So in the meantime, WIPO issued two more notices of irregularity on one more classification issue, and in response to the email to WIPO. So you just need to make sure that you're letting yourself have a lot of time. Roberto, did you have a couple other things you wanted to mention? I see that there is one question here, and then I have sort of a thought or a question that I'm going to throw out, and that is in talking about central attack. Can you force an opposer in another country I suppose you cannot force an opposer in another country to make a central attack, but if someone raises a central attack and is unsuccessful, can they still oppose or challenge the mark in other countries? And I expect the answer is yes, but I don't know that. Is that the case, Roberto? So they can bring sequential or serial oppositions or cancellation actions, even if their central attack is denied in the U.S.
Yes.
Yeah.
Yes.
Which makes sense, given that they are, could be a totally different basis for refusing or canceling, challenging, opposing, or canceling an application in another country. Chris, shall we turn it over to you for questions?
Yes, that's wonderful. Thank you, speakers, for your insights today. Before we do go to questions, I have a brief announcement. New York and Kansas states do require that you record and report the following code to obtain CLE credits for the live or recorded version of the CLE webinar. If you will be requesting CLE credits for the seminar, please do write the code down. The code is TLHP6A. So that's T like Tango, L like Lima, H as in hotel, P like Papa, the number 6, A like Alpha. One more time. That code is TLHP6A. So now on to our live question and answer session. Listeners, you can ask our speakers any questions now relevant to today's topic, or you may email questions to iplaw@stratfordpub.com, or submit questions now by typing your question into the Q&A box on the right side of your screen and pressing Enter there. So there are a few questions. I'll read them out to you. The first one is, can you challenge an international registration in a U.S. court, giving the example that if the IR is based on an Australian trademark, would you challenge the original trademark in Australia?
Well, I'll take an initial stab at that. I don't, you can't, central attack means challenging the underlying basic application or registration in the country of origin. So you couldn't challenge, when you say challenge an international registration in a U.S. court, you can challenge a U.S. registration or application that forms the basis of an international registration. And if the U.S. application is abandoned as a result of that action, or if the registration is canceled as a result of that action, then and it's within the 5-year dependency period, then the international registration is canceled as well, and all of the designations fall with the international registration, with the option to transform the registration in any of the designated countries. So if the question is, so if the IR is based on an Australian trademark, would you challenge the original trademark in Australia? Yes, you wouldn't have a basis for challenging in a U.S. court based on an Australian registration. So I hope that answers the question. And Roberto, do you have anything to add?
No, I agree.
Okay.
All right, the next question is, where do you go on the WIPO site to sign up for the e-notifications? Can anyone take a shot at that question?
Oh, I'm sorry. I was muted. I apologize. No, I was in Catherine. I can send you a link to that. That's probably the easiest thing because I don't have the URL right here. If that's okay?
Yeah, sure, that's fine. If you wanted to put the link in the message area, I can send it off to her now.
I don't have it then.
Oh, I got you. Okay. All right, then post-event we'll do that. Thank you.
Okay.
All right. Next question is, please re-explain when temporary assignment procedure may be needed, as referring to slide 16.
Okay. Roberto, I'll take a crack at that one, or do you want to go? Go ahead. Well, it would be needed when the country in question doesn't accept consent a letter of consent or a consent agreement. So in Japan, for example, Japan will not accept a letter of consent from another mark owner. And so the way you get around that, if the prior registrant is cooperative, is that you, as the applicant under the IR, assign just the Japanese part of just the Japanese designation under your IR to the earlier registrant, so that at that point the two marks are owned by the same owner and there's no longer a basis for objecting then to registration of the IR. And then once the grant had issued, and Roberto was really clear about waiting until the Statement of Grant of Protection has issued, you can then reassign just the Japan portion. What they'll do is they'll keep the same IR number and they'll give it a letter designation. It'll be, IR 1234567A. And then after the registration is granted, the earlier registrant who owns the registration temporarily, or the application temporarily, will assign it back to the original applicant. And then at that point, you can file a request with WIPO to merge that IR back into the original. So it's what you do when you can't offer a consent, when the Office of Origin, and there may be other, Korea comes to mind. Korea and Japan are the two countries where I think this is most common. Are there others, Roberto?
No, those are the ones that strictly do not accept letters of consent.
Right.
There are some others. Georgia does not, and maybe some other Eastern country, but Japan and Korea are the most important ones.
Right. So typically you would have that agreement. You have a simple agreement with the earlier registrant that just says this is what you're going to do. You may even do all the documentation ahead of time, and you would have your local counsel who would record, you would do the assignment with WIPO, the partial assignment, but then your local counsel would make any necessary response to the trademark office and then record anything that needs to be recorded or draft any agreement for reassignment, possibly. Well, depending on exactly how you're doing it. But it's WIPO forms if you're assigning the WIPO application.
All right, the next participant is saying that you stated that sometimes a provisional refusal before the end of the 18 months may be recorded as an actual refusal in the National Register. So the question, is there a way to know which nation may do that?
Roberto?
Yeah. All countries enter the result of their examination into their national register, effectively. And when they issue a provisional refusal, when they enter one into their national register, they notify WIPO at the same time. So basically, all countries do that.
So it's provisional, but it's provisional in the same way that a non-final office action in the U.S. is provisional. So it's entered as a refusal, but you have the opportunity to respond to it to try to overcome the refusal in much the same way. But typically at that point you are hiring your local associate to do the response.
All right. This person, I think it's a question, is can second part fees be paid through USPTO?
No.
Okay.
I don't. Well, wait a sec. Maybe I'm wrong, but I think that second part fees have to be paid through WIPO, and I'm quite certain that I've seen that. Do you know, Roberto? I don't think there's an option to pay those through the USPTO. Mike, if you're on, do you know? So I would just pay those directly, especially because the time frame, it's not extremely short, but it just makes me so nervous to get those paid right away that I would just pay them with WIPO, through WIPO. Because but I'm pretty sure you can't do that.
Okay. All right, this person is asking if you could please re-explain the difference between an e-form for IR and a paper from form. And Dr. Kluns-Hallstein mentioned something about renouncing.
Yeah. You can do everything on paper. What you have to do with WIPO. But there are some some measures you can take electronically, such as e-subsequent designation, e-renew, or the e-limitation. Both, either paper or electronically, are equivalent. I just don't like the e-limitation because with the e-limitation, as the system is designed now, you cannot specify. Meaning you cannot say if you have pharmaceutical preparations, you cannot say pharmaceutical preparations, namely whatever. You have to either renounce to the goods or you cannot limit. That's one way. In paper, you can specify.
Okay, thank you. Next question is asking the following. Are there certain jurisdictions where you file nationally rather than through WIPO because of enforcement issues?
Well, yes. In theory, an IR gives you an equivalent to the national registration. So from a strictly legal standpoint, there should be no reason to rely on a national application. However, especially when a country has recently joined Madrid, or when there are few designations in this country, then the judges may not be so familiar with the system and the provisions. Life will be easier if you have a national registration. I hope that answers the question.
Okay. Okay. If not, you can submit an additional message for him to respond to the participant that asked that question. Next one is asking, can you provide the list of countries that require recording with the National Office for Licensees? Or license, excuse me.
I can do that, but not right now, because I cannot access the list. Maybe I can send an email.
What I can do is, I thought maybe your email addresses were included and they could directly email you that question.
Can I just make a comment about that? Am I unmuted? I think I am.
Yes.
I would probably, in any event, if you have a license that is going to be effective in a particular country that you've designated under your IR, I would check with the local council anyway, and probably, because you probably need to have it recorded by local council. So, I mean, if it's that, I think that would be one answer to that, is you would just check in each country where you have where the license will be effective. Although I suppose if you have a worldwide license, then it's going to be wherever your IR is designated, but that's one thought, particularly if you wanted to be really certain about it.
All right. It looks like there are no further questions, and we're out of time. Any final thoughts or anything either of you would like to check before we close?
Just that my colleague confirmed that you cannot pay the second part fees through the USPTO. So the answer was no.
All right. Thank you both again, and thank you, everyone. We do hope you've enjoyed our national webinar, Madrid Protocol, Obtaining and Maintaining International Trademark Protection. If your question was not answered, you may email it directly to our presenters. Their email addresses are included in the presentation materials. If you are seeking continuing education credit, you must verify your participation in this webinar by completing and submitting the attendance affirmation evaluation after the program. A link to that form will be included in the thank you email that you will receive immediately following the program. And as long as you've registered and paid for it by 5 p.m. today, you will receive your certificate of attendance within 24 hours. Should you have any questions about continuing education credit for this webinar, please just call our continuing education department, and I'll leave you that number. It's 404-881-1141, extension 2. Today's participants can order a recorded version of this event at a special attendee price. For that, please call customer service at 800-926-7926, extension 1, or you can just visit Stratford's website, which is stratfordpub.com. If you're not yet a Stratford Annual Pass holder, do try the CLE Individual Annual Pass, where you can get all your CLE credits for one low price. Simply respond to the email you will receive after the program. Stratford would like to thank you all again for your attendance, and to end this call, simply close your browser. Thanks so much, everybody, and enjoy the rest of your day.
Thank you for using the conferencing center.
All right, that went very well. We're back.